Magandang araw sa inyong lahat at welcome po muli sa Payo ng Abogado. Para sa video module na ito ay ipagpapatuloy natin ang talakayan tungkol sa that the act be committed with abuse of confidence or obvious ungratefulness. Ang discussion natin dito ay iikot sa isang sample case. Pero bago ang lahat ay talakayin po muna natin kung ano ang nabanggit sa previous video. Number 4. That the act be committed with abuse of confidence or obvious ungratefulness. For the existence of this circumstance, it is necessary that there exist a relation of trust or confidence between the persons committing the crime and the one against whom it is committed, and that the former make use of such relation to commit the crime. For example, a kasambahay took away all the jewelries of his or her amo. Here is the sample case. Petitioner was the accounting clerk and bookkeeper of Video City Commercial Incorporated and Viva Video City Incorporated. She was assigned to handle 12 Video City store franchise accounts, including those of Tommy Uy, Wilma Ong, Jefferson Tan, and Sharon Coneta. Taking advantage of Tan's constant absence from the country, Petitioner was able to use Tan's joint venture bank account with VCCI as a clearinghouse for her unauthorized transfer of funds. Petitioner deposited VCCI checks coming from other franchisees' accounts into the said bank account and withdrew the funds by writing checks to her name using the checks pre-signed by Tan. It was only after Petitioner went on maternity leave and her subsequent resignation from the company in May 2002 that an audit was conducted since she refused to turn over all the financial records in her possession. It was discovered that she made unauthorized withdrawals and fund transfers amounting to 4,877,759 pesos and 60 cents. What is the ruling? The elements of the crime of theft as provided for in Article 308 of the Revised Penal Code are as follows. Number 1. That there be taking of personal property. Number 2. That said property belongs to another. Number 3. That the taking be done with intent to gain. Number 4. That the taking be done without the consent of the owner. And number 5. That the taking be accomplished without the use of violence against or intimidation of persons or force upon things. Petitioner is guilty of the crime of qualified theft. Theft becomes qualified because, number 1, the theft is committed by a domestic servant. Number 2, the theft is committed with grave abuse of confidence. Number 3, the property stolen is either a motor vehicle, mail matter, or large cattle. Number 4, the property stolen consists of coconuts taken from the premises of a plantation. Number 5, the property stolen is fish taken from a fish pond or fishery. And number 6, the property was taken on the occasion of fire, earthquake, typhoon, volcanic eruption, or any other calamity, vehicular accident, or civil disturbance. As long as the property taken does not belong to the accused, it is immaterial whether said offender stole it from the owner, a mere possessor, or even a thief of the property. The total imposable penalty for simple theft should not exceed 20 years. As the penalty for qualified theft is 2 degrees higher, the trial court, as well as the appellate court, should have imposed the penalty of reclusion perpetua. Sana po ay may natutunan kayong muli sa video module na ito. Abangan po natin ang susunod pang video. Salamat!